Let's dig into rollover relief now.
So if you've got an investment property and you transfer from one partner to the other, right, then there's no capital gains tax payable on that at that point of transfer, because it's not a trigger event. It's not until that property's sold the capital gains tax is triggered. And so if there's capital gains tax applicable, well, it might be applicable if that property were to be sold. When it's transferred from one part to the other, the capital gains tax liability transfers to that partner, whoever's going to finish up with that property. And so the whole of that capital gains tax will then be incurred by the party who's keeping that property.
Welcome to Get Invested on the Property Hub podcast channel, the leading weekly show for Australians who want to learn how to unlock their full self, health and wealth potential. I'm your host, Bushy Martin, and each week I go deep with the best investors, experts, leaders and founders to find out what it takes to break free from the grind, discover freedom and to live by design. Subscribe now and join me and get invested in the life that you really want. Let's get started.
Hi, freedom fighters. How would you feel if you lost everything that you've spent your whole life working towards? Could be a flood, fire, or even worse, the breakdown of your relationship. Because if you've ever gone through a divorce or separation and property settlement, you know that it's a terrible time that sets you back in every direction and leaves lifelong scars. And I know this firsthand because sadly, for my first wife, my son and myself, we've been there and I wouldn't wish it on my worst enemy. So if you end up in this situation, and a lot of you may unfortunately, how can you better navigate this for everyone's benefit? Let me set the scene by getting you to imagine this. The house is too quiet, it's too still. The silence that had once been comforting now presses against my chest, squeezing until every breath feels like a plea. I sit on the edge of the bed that I'd shared for years, my fingers retracing the faint indentation on her pillow, the last remnant of her. She was gone, not in the absolute sense, but the space between us had become an ocean that I could no longer knew how to cross. Conversations had dwindled to logistics, to polite exchanges over bills and schedules. Love had once been a force so powerful between us, but now it was a fading echo in an empty house, thanks to my self-absorbed workaholism and exhaustion. My hands trembled as I reached for the letter that I'd written, but just couldn't bring myself to give it to her. I miss us. 3 words at the centre of all the pain, all the longing and all the fear. Because what would happen if us no longer existed? When I first met her, I felt instantly head over heels, full of dreams, laughter, and the naive belief that love could conquer just about anything. And for a time it did. Our love had been a home, a shelter against the storms of life. But homes too can fall apart when they're left unattended. Somewhere between careers, disappointments, overcommitments and unspoken resentments, we'd stopped choosing each other. And now here I was staring at the crumbling foundations, knowing we were about to lose everything that we'd built. The future stretched before me like a vast, terrifying void. Would I be alone forever? Would I regret letting go or regret holding on for too long? Who was I without her? Who was I without the love that had once defined me? And then there was the very scary financial reality. The home we had built together, the one that once symbolised our future and was full of our memories, would have to be sold. The accounts we had merged, the savings and investments we had grown, all would be divided like a broken dream. I thought about the legal fees, the property settlement negotiations, the long and inevitable disentangling of our entwined lives. I built my world with her and our son, trusting in a future together, and now I faced the staggering uncertainty of starting again with nothing in my mid-30s. The thought of breaking up felt like erasing a massive part of my life. Would I have enough to sustain myself? How could I rebuild from scratch when I was burnt out, broke and broken? This is exactly how I felt when I went through my painful marriage split many years ago. And while things have actually worked out well for me with my new life partner and all things Sonia, the lessons I learned during that harrowing time mean that if I had my time again, I'd do things very differently. And one of those things would have been to have prepared a binding financial agreement, or BFA, because you need to plan for the worst and then manage for the best in everything that you do, which is what we're going to do in our continuing dive today. And if you don't have a BFA, make sure you and your partner prepare one, because it's never too late to do so. And the sooner, the better, if you really care about protecting your family and your loved ones both now and in the future. Like insurance, let's hope you never need it and it collects dust on a shelf. But if you ever do, and between 4 to 7 of you out of the 10 of you that are now listening are likely to, at a time when you can at least afford to, and you'll be forever glad that you did. So do your family and your future self a massive favour and get a BFA done ASAP. It'll give you the peace of mind of knowing that if the wheels fall off your relationship for whatever reason, that you're all going to be okay. And you'll save yourself an immense amount of pain, stress, heartache and legal costs, as the only winners in relationship splits are the taximeters in the lawyers' pockets. And today's returning guest, Ian MacLeod from RP Emery and Associates, can help you prepare a fair and reasonable binding financial agreement as he shares what they're all about and what they mean to you in your future. As you'll remember from our last episode, Ian's a seasoned professional with over 15 years of experience helping couples like you create legal binding agreements that define how finances will be treated before, during and after their relationship, where he serves as a conduit between the legal and the non-legal worlds. So whether it's helping you or other couples who are proactively protecting their assets from a future family law claim, or assisting those who have already agreed on property division, Ian's focus remains on mutual agreement and keeping you out of court. Because, importantly, his approach prioritises avoiding the adversarial nature of the legal and family court systems, offering a more harmonious, efficient and cost-effective alternative that preserves relationships and drastically reduces legal costs. I just wish I'd known Ian back when I went through my marriage split. Now, last week we dug into the binding financial agreements, or BFAs, when you're getting together and staying together. Well, this week we're going to explore more of the ins and outs of BFAs for separation. So welcome back and let's get invested again, eh?
How you going, Bushy? Thanks for having me back.
Yeah, no, we had a great chat last week, mate, and we really only just sort of scratched the surface. But before we sort of get into the nuts and bolts of it, Ian, can you just refresh us on why and how you do what you do and how this actually benefits others in this context?
Yeah, sure. Okay. If you didn't catch it last week, I just need to point out I'm not a lawyer, right? We are RP Emery and Associates are a legal publishing service. We're not a law firm. And we provide a kit. So couples who are looking at putting an agreement in place either before, during or after the relationship. So we can help you put an agreement in place, whatever stage of the relationship you're at, right, to help you dramatically save in legal costs and help to avoid having to go through the court system. All right, because when if you're in a separation, if you're going through trying to divide your property, you essentially have the choice of, you can go through the court system, where you can, if you agree, you can ask the court to, let me back up. If you agree, you can make an application for orders by consent, meaning that you present whatever it is you're proposing as far as the split goes. You can present that to a magistrate, and the magistrate will then say, well, that's fair and reasonable, or it's not. Now, if it's not fair and reasonable in the eyes of the magistrate, you go back to the drawing board and have another crack. Now, the second option, if you are not in agreement and you are asking the court to decide how to divide your property, then you've just given up any control that you might have had.
Yeah.
If you wanted some control over how this might pan out, you've just handed it all to the court and the unknown. The other option that you have is if you agree, if you can get to a point where you have a meeting of the minds, then you can set your agreement out in a financial agreement or a binding financial agreement, and you don't have to go through the court system. It's a private contract between yourselves, which will help you divide property, help you avoid stamp duty, help you if there's capital gains tax implications or property that's to be divided, you can qualify for what we call capital gains tax rollover relief. I don't know if you're familiar with that. You may be. We can go into that a little bit later on.
Yeah.
So you can set it all out in a private agreement between yourselves, which then essentially closes the door to the family court. So once you've set it out in your agreement, then you cannot bring another action in the family court in relation to what you set out in that document. Now, before a binding agreement has any binding effect, both parties must receive legal advice. Now, that legal advice pertains to your rights. So a lawyer has to explain to you your rights as they are at the moment. Right? And in the absence of any other agreement, then you have the door to the family court is open. Right? So before you sign an agreement, you have access to the family court. But once you sign the document, you give up that right. You give up your right to access to the family court. The lawyers also have to explain to their client whether or not signing that agreement is to your advantage or to your disadvantage.
Okay.
And so what that means is they look at it with from trying to use the eyes of the magistrate and say, is this agreement fair and equitable? Is it reasonable? Is it what you might expect to get if you went through that court system? Is it within the scope or the range of what you might expect to get? Now, if you could expect to get a better result going through the court system, then it might be said that the agreement is to your disadvantage. Okay?
Yep.
So the lawyers have to explain to you whether that agreement is to your advantage or to your disadvantage. Now, once you have that information, once you understand it, then you can make a conscious decision about whether or not you want to sign that agreement as it is, or whether you want to go back to the negotiating table with your ex-partner and see if you can come up with a better outcome. All right? But the important thing is when you put pen to paper, even if you're disadvantaged by that agreement, and sometimes people are quite happy to go, look, I know that I could probably get a bit more if I go through the court system, but I don't want the emotional, the emotional costs that go along with that. I don't want the financial costs that go along with that, right? And they might be happy to go, look, just to put it behind me, I'd rather just accept this deal the way it is rather than continue to fight. Now, I'm not suggesting that people do that. I'm not suggesting that they just accept whatever's put together. What I'm suggesting is you still have the power to negotiate with the other party, right? And if you decide that you want to go ahead, then you are doing so with informed consent.
Yes.
You know what you're doing, and that's the whole point of getting the legal advice, right? And bear in mind, you have varying degrees of inequity. An agreement might be just like a little bit inequitable, and there's always going to be one partner who's advantaged and one partner who's disadvantaged, right? Yeah. But it might be just like a tiny little bit, or it might be a lot. All right. If it's a lot, if there's a large degree of inequity, then the lawyers might be looking around and go, well, why would this person accept can I say shitty deal on this?
So finance, yes, you can.
Why would they accept something which is so clearly to their own detriment? Now, if that's the case, then the lawyers are going to be looking for evidence of family violence, duress, one party saying things, like you either sign this agreement and you'll never see the kids again, things like that. Right? So, once again, please only come to us if you've got genuine agreement. Don't come to us if you've been beating your wife about, Yeah. It won't work. It will not work, right? Because it'll eventually unravel.
Yes.
And, it's just, how do I say it? It's just, you've got to be open and honest with the person you once loved deeply.
And fair and reasonable in the resolution and all that. Now, you sort of touched on earlier the court orders, and banks often prefer court orders before releasing funds when one person is buying out.
Yes, that's true. Yeah.
Is there an advantage to using a BFA instead?
The banks will accept a BFA just as they accept a court order for that purpose. And the only real benefit one over the other from the perspective of the bank, I suppose, is that you can get a BFA done much quicker.
Yes.
Where you're not waiting for the court to have an opening, because the family court's got so much work to do. It might take you 3 months to get your matter before the court, and then there's still no certainty whether it's going to go through. And, like if you've got pre-approval for your loan, for instance, you're going to buy, one partner's going to buy out the other, all right? We've got pre-approval. Right? Well, generally, pre-approval runs out at about 90 days or something. Doesn't it?
90 days, exactly right. Yep.
Yeah. So then you start all over again. If you're waiting for the courts in that.
Yeah, that's okay. And again, we touched on this in our discussion, but just to drill in here, does a BFA qualify for a stamp duty exemption, or is that only available with a court order?
No. A large proportion of our customers come to us where they say, "Oh, we've just done everything ourselves anyway, all right, but now we want to transfer the house, and we find out, we're going to have to pay stamp duty," right? So, particularly in New South Wales and a few other states, you need either a BFA or a court order so you can sidestep that stamp duty.
Yes. As a spousal transfer.
And then if you've got an investment property, there's the capital gains tax rollover relief as well, right? So I'm not sure.
Yeah, let's dig into rollover relief now, because I think you mentioned a couple of times, just for those who might be going, what are these guys talking about?
So if you've got an investment property and you transfer from one partner to the other, right, then there's no capital gains tax payable on that at that point of transfer, because it's not a trigger event. It's not until that property's sold the capital gains tax is triggered. And so if there's capital gains tax applicable, or it might be applicable if that property were to be sold, when it's transferred from one part to the other, the capital gains tax liability transfers to that partner, whoever's going to finish up with that property.
Yes.
So the whole of that capital gains tax will then be incurred by the party who's keeping that property.
Yes, and that's probably if you're looking at the overall pot and the division thereof, then the party who is not going to have the property, that the couple need to take in consideration the potential capital gains impact, because it will have a monetary effect at some point in time.
Yeah, but like if you've got we quite often find that one party will keep the family home, and the other party will keep the investment property.
Yeah.
Right. So whoever's keeping the investment property keeps the capital gains tax liability, but that if they're just going to stay in that house forever and a day, it's never going to be paid. It'll never be triggered.
Right.
And yeah.
So it's not an easy one, is it? Because if it's been an investment, let's say it's been an investment for property for 10 years and would incur capital gains for that period, and then the partner moves into it, then it's prorated, the capital gains tax. Again, I'm not an accountant, so this is not accounting or taxation advice, but it certainly needs to be weaved into the equation because it might seem simple. Oh, well, you stay in the home and I'll live in the investment property. That the home's never going to incur capital gains because it's capital gain exempt, whereas the investment property, there will be a prorated portion of that. So the devil's always in the detail with this stuff, and that's where the appropriate advice, legal advice and accounting and taxation advice, part of this whole exercise becomes pretty paramount to make sure that it does end up being fair and reasonable at the end of the day. So great topic to mention there. What about superannuation? How does that work in a BFA? Yeah, can it be split as part of the property settlement, or how does that operate?
Yeah, absolutely. And the trustees of the super fund cannot transfer from one party to the other. Pardon me.
No.
Yeah, a little bit of a cough that I've been trying to shift. So the trustee of the fund can't split the superannuation interest unless they have an order from the court or a BFA. Yeah, one or the other. And the same goes if you've got a self-managed super fund. Yeah. The auditor of that fund won't be able to sign off on any transfer of balance unless you've got a BFA or a court order. Yeah. So, but if superannuation is one of those things that you want to split, you need to know a little bit more about it, feel free to give us a call. I can help you with that.
Yeah, no, awesome. Now, the question that's going to be on everyone's minds, Ian, is what are the costs involved in preparing and finalising a BFA? Can you sort of give us a bit of an indication what that looks like?
I would recommend everybody do their own research, because if you go, I can pull figures out of the air for what other people might charge, right? And some law firms will charge as much as $20,000 to put a BFA in place, depending on what's in the property pool, how much money's involved, right? If there's a lot of money involved, then there'll be a lot of cost involved. Right? And a lot of that, a lot of big city law firms, that's those sorts of costs are pretty normal. Yeah. However, if you were to go to, maybe a smaller suburban sort of firm, you might expect those costs to be much lower. Maybe $5,000 to $10,000 to draft an agreement and provide that legal advice. But then remember, your partner also has to receive legal advice. Costs might not be exactly the same because you haven't got the drafting of the agreement, but they still have to receive the legal advice, and there may be toing and froing between the lawyers over the end result, and that's all still just a big black hole. Yeah. The way we work is you would purchase a kit. Now, the cost of that kit could be anything from $147 to $247, depending on whether or not you need to split a superannuation interest or not. Once you will then draft the document yourself, following the instructions, and look, most people who understand what an assets and liabilities statement is and they can operate Microsoft Word won't have any difficulty in following the template agreement. We're only asking for information that you already have in your head. Things like name, address. Have you got any children? What are their names, dates of birth? Got a car, make, model, registration number, bank accounts, superannuation accounts, credit cards, all that sort of stuff. Yeah. Those things do need to be identified, right? We don't ask for like a full bank account number or a full credit card number, but you might have to put in there, look, I've got an ANZ Visa account, right? It's $4,600 on it, and the last three numbers of that account are 759. Right? So just enough information to identify that account, because what you're doing is you're trying to look at this agreement with the eyes of somebody else further down the track. Might be, if it were ever challenged or came before a court or another lawyer, you'd have the first thing they'll be looking at is to make sure that both parties have made full and frank financial disclosure. So if you're saying, look, I've got $257,000 in my superannuation account, somebody's going to want to confirm that. And so you need to be able to produce a statement that with a number or something that says, that we can confirm that's what it was at that time. Make sure nobody's trying to mislead the other party.
Yeah.
Now I've forgotten what the rest of the question was.
No,
I'd like to know.
No, you've covered the cost side of it pretty clearly. Yeah, and
oh, hang on. Well, no, I didn't cover the cost. That's the cost for the kit. Then you need the legal advice component, right? So I have a relationship with 5 lawyers who are happy to provide that legal advice for a fixed fee. Now, that fixed fee is $2,790 at this date. Put a date on that because it might go up next year. It's $2,790 at the moment, and that gets you the legal advice for both parties.
Okay.
So you've got the cost of the kit plus the legal advice. So you can be if it's a relatively straightforward matter. Now, when I say relatively straightforward, we're not talking about multiple companies and trusts, and you've got property in your self-managed super fund with a bare trust and all the complexities that go along with that. Right. But if you've got a relatively straightforward matter, you can be out of it for about $3,000. And anybody who's been through this mill before will know the pain and suffering, both emotional and financial pain, of trying to fight these things out through courts and getting, having 2 opposing lawyers, right, trying to nut out a deal for you.
Yeah. That's a pretty cheap ticket. I went through that horrible exercise 25 or more than 25 years ago now, and even then, what you've just mentioned is a fraction of the hip hop cost.
Oh yeah.
Let alone all the stress that you go through as a result of that. So something I wouldn't mind just testing a little bit because
sure.
Well, I'd love your thoughts on this one, but let's say in the emerging world of crypto, there's an agreement that says, okay, well, one party's got some crypto, and at the time they do the BFA, it's worth, I'm going to pluck a number, 20 grand. And then when it all comes to fruition, suddenly the crypto is worth 5 million, because you see those sort of levels of ups and downs, which could skew, depending on how it's treated within the BFA, it could skew the pot pretty considerably. Does that fall into the question mark of fair and reasonable when it's assessed at that point in time?
Yeah. So if you've signed an agreement during the relationship or before the relationship, okay, where it says, okay, well, I've got, I don't know, I've got 3 Bitcoin or whatever. Good luck to you if you have. So you would list the number of that crypto, right? Its value is going to fluctuate all over the place, just the same as an interest in the share in the company
market. Yeah,
they'll fluctuate from all over the place. All right. So when you make that agreement, so long as you identify that asset and you identify it fairly and clearly, and it's unambiguous, then that shouldn't ever be a problem down the track.
Yeah.
It might provide, like if that asset has gone through the roof, it might provide an incentive for somebody to try and say, well, I'll have a go at trying to challenge the agreement because it's unfair now.
Yeah.
But there's nothing in the Family Law Act that says an agreement has to be fair.
Yeah.
Right. If you strike a poor bargain, well, that's unfortunate. So there's nothing that says, you know, every bargain has to be fair. But you know, so long as you're open and honest and say, well, that's how many Bitcoin I got, and that's what they're worth today, right? And that's my separate property. It's not joint property. Yeah. Then that's pretty clear. Yeah. All right. So that doesn't provide grounds for a challenge at all.
No, okay, that's good. That makes it crystal clear. And before I get your sort of key takeaways on the whole subject of BFAs, is there anything important that we haven't covered that is worth mentioning?
Oh, look, there probably is. There's probably something out there, whether I can think of it at the moment. But, you know, it really just comes down to honesty.
Yeah.
That's all. It just comes down to honesty when you're dealing with the other party, and you don't try to take advantage of them. Yeah. Don't try to mislead them. If you try to mislead the other party and you get caught out, it's going to cost you dearly, because if you get caught out not disclosing assets in your BFA, right, and it comes before the court's going to be really harsh on you. You know, you're going to lose far more, right, in that instance if you get caught out. It's fraud, and it's called non-disclosure of a material matter.
Yeah, yeah, and so it should be treated harshly, because it's it's dishonest. There's no question about it. If we sort of wrap a bow around the whole BFA subject, what are some of the key takeaways that we need to take on board when we consider BFAs in terms of our protection and the benefits thereof?
Look, they are not an absolute surety that you will be protected. Right? Nobody can tell you that absolutely positively that thing's going to be rock solid and it's always going to protect you, because we don't know what's going to happen in the future. All you can do is work with what we have today. People say, come to me and say, I want to make sure this is absolutely positively rock solid and it can't be, can't ever be challenged or whatever. No one can make that promise. Right? Mm-hmm. So I liken it to, I'm going to go out and buy a little block of land, and I'm going to put all my worldly wealth in that land. I'm going to build a big fence around it, and I'm going to put in a moat and some crocodiles and a drawbridge. All right. It doesn't mean that somebody's not going to try to scale the fence, all right? But you'll make it a lot harder for them.
Yeah, and the peace of mind of at least going through that process when there's rational discussion, rather than in the war zone of a breakup, compared to throwing petrol on the fire with the conflict that often comes from legal representation on both sides. And it's much better bet.
And it's much easier to put these things in place when you're happy and looking forward to a life together. You're looking forward to living happily ever after. There's a meeting of the minds and there's an understanding between the parties. It's much easier to do this rather than getting years down the track and then going, now things are starting to get rocky. Now I want to put an agreement in place. Good luck.
Exactly. Well said. The
horse is bolted.
Yeah, absolutely. Now, we've only touched on one area that RPM and Associates and yourself deal with. So I will get you back to dive into those in future, because let's face it, we're becoming, the whole world's becoming more litigious, and if you're not protecting yourself and having things in place, you're really exposing yourself to considerable risk. But the last question I always like to ask people, Ian, is if I ask you to get invested, what does that mean to you?
I mean, to me to get invested, look, you mean if I'm looking for an investment today?
Well, no, it can be anything. Time, energy, money, you name it. What does get invested mean to you?
I do like, well, I do like intellectual property as an investment.
Yeah.
I do like the idea of having, like we have a website that just does its thing 24/7. Provides me with a lot of freedom, and I use the, not that it's a huge amount of wealth, but whatever I get from that, I like to move that into real estate. Yeah. Right. So, that's my investment.
Yeah, no,
philosophy.
Yeah, no, that's awesome, mate. So we will definitely get you back. For those that are listening and going, I really need to get a BFA in place to give me that peace of mind and protection for the future without the risk of the legal harangue and massive expense and pain and heartache that comes from leaving it to the alternative. We'll make sure we've got all of your links to your websites, etc., in the show notes, so it's going to be very easy to jump in. Now, we spoke off air about, I like to challenge anyone listening to a call to action or a challenge. Have you got anything that you'd like to offer in that regard, Ian?
Yeah, look, I'm always open to having a chat. You can send me an email through our website, all right, but we'll always ask for a phone number. All right, so I can pick up the phone and respond verbally. I type with two fingers, and sometimes it takes a little while for my thoughts to form on the paper. All right, I much rather pick up the phone and have a chat to somebody. All right, so if you have questions, you have things you want to protect. Right? If you want to protect your wealth, just phone the number on this screen. Phone the number on our website.
Yeah.
All right. Call me now.
Yeah. No, easy, mate. And one thing I will suggest people do is jump onto your website via the link in the show notes to grab a copy of your ebook, Living Together and Your Financial Future. It'll certainly head you in the right direction as far as that goes. So look, really appreciate you coming on, and I really want to thank you for taking the time to educate us on all the benefits and intricacies of preparing binding financial agreements to best protect our families and future interests over the last 2 episodes. But before we close, if anyone listening would like to keep the conversation going, a very safe and open forum where you can take your knowledge to the next level by sharing and learning with other like-minded investors and property professionals so you can get all of your questions answered, join Eddie the Frenchman, myself, and a host of others now on the Property Hub Collective Facebook page by clicking the link in the show notes. And that brings us to the end of another great and very enlightening conversation. So thanks again for getting invested, and let's make sure we keep the conversation going there.
Thanks, Bushy. I really appreciate it. I've enjoyed our chat.
Likewise. Cheers, mate.
Thank you. Cheers.
Thanks for tuning in to Get Invested on the Property Hub podcast channel, your home for property investment insights and inspiration. Make sure you subscribe to Property Hub for free. Get your weekly dose of Get Invested inspiration along with every episode of Realty Talk, Australia's top online property show for red-hot property investing news and insights direct from industry leaders and influencers. And finally, I'll see you next time.